Hello, everyone, and welcome to today's webinar, Software Patents in Europe. My name is Dr. Jochen Reich from Reich-ip law firm based in Munich. Currently, we have 4 locations all over Europe, and we handle software patents, hardware patents, and IT patents in general. Today, we will learn something about obtaining patent protection in Europe, and this webinar is directed towards attendees who are familiar with patent protection, especially PCT applications entering EP regional phases. And now we will have a look into the slides. Let us begin. So, German and European patents attorney. We specialize in computer science. Today, we will learn about software patents in Europe, especially, and with specific insights in German patent practice. First, I will give you a motivation why you should really consider filing patents in Europe. I will present some numbers provided by EPO, European Patent Office, and we will learn that software patents and especially AI patents are an emerging business, and it is really worthwhile applying for patent protection in Europe. Furthermore, we will learn about patentability for a European Patent Office. What are the requirements? What do you have to consider? And with special focus on computer implemented invention, which is a rather specific topic which cannot be compared to conventional patent protection, for instance, in mechanical engineering. So there's very specific case law that we will handle or have a closer look at procedural aspects. What filings are possible? What are filing strategies? What are post-grant strategies? And we will also cover financial aspects such as costs and efficient portfolio management. And afterwards, we will have a Q&A session, which will not be recorded due to privacy concerns. So let us start. First of all, just for your motivation, European software patents are really rising for the last years. And if you have a look at the right-hand side chart, you will find that digital communication, medical technology, computer technology is really rising as regards application numbers before European Patent Office. So these are things that really address software patents. For instance, digital communication is mostly about software. In the field of medical technology, you will find that these approaches typically also imply software issues such as image processing and the like. And what we learn from this slide is that the numbers are really rising in Europe. And this is really an emerging market, as you will also learn from this slide. So computer technology is one of the most active fields as regards patent applications in Europe. And on the right-hand side, you will see that top applicants are Huawei, Samsung, Microsoft, Alphabet. So this is really an emerging market with global players. So this is a huge rise in the numbers of patents before EPO. And as you all are aware, also international patent application numbers are increasing over the years. And this is also the trend in Europe. And when it comes to examining patent applications, the examiner typically cite English or maybe German prior art documents. So Chinese patent applications are extremely rising. So they are typically not considered during grant procedures or examination procedures. So this is something you have to keep in mind that typically foreign prior art from non-English speaking countries is not considered. So you might still have a grant despite of several other applications. So the same applies for IA patents before EPO. Also here, the numbers are rising over the last years. And especially, which is not shown on the slide, the application numbers are rising in China and US, but still also before EPO. So this is really a matter why you should consider entering regional EP phases and especially not focusing on only US and China. So we will learn that patentability in Europe, it can be achieved. There are specific requirements, specific guidelines, but they have a very strict roadmap regarding examination. So when drafting the applications, we know about what is about to come, and we can consider this when drafting. And even if we receive already drafted applications from foreign countries, we know exactly the roadmap and how to argue before a European Patent Office. So if you consider obtaining patent protection before EPO, you will probably be familiar with some aspects of European patent practice and others not. In this webinar, you will learn the general guidelines and you will receive important hints how to obtain a grant before European Patent Office. So this will be the next issue, the substantive aspects regarding patentability, because when it comes to the examination procedures, we have very specific case law regarding computer implemented inventions. And these will be addressed in this webinar. Further, we will go to procedural aspects. But first of all, what is patentability? How is it handled by European Patent Office? So patents shall be granted for any invention in the fields of technology, provided that they are new, involve an inventive step, and are susceptible of industrial application. So first of all, what is an invention? What is a technical field? What renders an invention technical? And we will learn about the exclusions from patentability. When it comes to novelty, we have to first identify what is the prior art. So what is really a disclosure? When is a technical teaching disclosed? When is it made available to the public? Once novelty is established, we will handle the inventive step issues. So we have the so-called problem solution approach before EPO, which is a very strict roadmap, and we know exactly which arguments have to be provided to obtain a grant for a software patent application. So the next thing is the industrial application, which is typically given. So this is not a big issue. So next thing is, what is novelty? What is an invention? What is an exclusion from patentability? And as you can see on this slide, the German Patent Act is pretty much similar to the European Patent Convention, EPC. They're almost identical, but the case law is very, very different. And also the approaches, how applications are examined, are very, very different. So this is not only an aspect that addresses geographic issues, but rather the examination procedures are different regarding German and European Patent Office. So what we see here is that what is excluded from patentability is programs for computers, presentations of information. So the thing is that we have to clearly consider what is a program for a computer and presentation of information as such. So this already reveals that there is a clear roadmap, what is patentable and what is not patentable. And just to provide a hint at this point, programs for computers can be patented, and we will learn how this can be accomplished before a European Patent Office. So when it comes to novelty, what is a disclosure? Which technical teachings made public? So in Europe, as well as before German Patent and Trademark Office, any disclosure, meaning any written or oral description, is a disclosure. Regarding software patents, we have very specific requirements. For instance, we have issues such as code obfuscation techniques. What is this? This if you take source code and you rearrange the lines or you rename parameters and you make it in a form that it is not any longer human readable but only machine readable. Is the invention still disclosed if you, for instance, deliver source code to your client? So typically, deliverance of source code is in compiled form. So what is if your client performs some reverse engineering? What is the issue if the code is encrypted? One might argue that if the client performs such things as decryption and reverse engineering, this may be understood under certain circumstances as a criminal act. So one could argue that this is not a disclosure. On the other hand side, if you provide a source code in form of a script, this is obviously readable by human beings. So I would argue that this is a disclosure of your invention. So you have to really make sure how you deliver your products to the client. If you want to make sure that you really have a publication in case you decide not to obtain patent protection, you can see on the right-hand side that there are services which do the defensive publication for you to make sure the invention or the technical teaching in common is properly disclosed and has a specific timestamp. So when we have established novelty, we come to the so-called problem solution approach when assessing inventiveness before EPO. And regarding software patents, we have combined with the problem solution approach the so-called convict approach or the convict decision, which has to be considered. So applying the problem solution approach, what is this? In the first step, you would determine the closest prior art. So this is typically one document which has the most features in common with your invention. So then starting from the distinguishing features, those are the new ones over the close prior art. The closest prior art document is just one single document. So those features who are left over, you have to formulate a technical effect. And based upon the technical effect, there is the objective technical problem, meaning if you have a distinguishing features like addressing the frame rate of a screen, there is a technical effect that the output of the screen might be enhanced. So Based upon this technical effect, it would be the objective technical problem to, for instance, improve the user experience when it comes to a screen. So what we do now is the so-called could-would approach, meaning that we take the closest prior art and we take the objective technical problem and we assess would the person skilled in the art arrive at the present invention starting from the closest prior art. So what is done? The closest prior art is taken, and then we would ask ourselves, would the person skilled in the art arrive at the present invention starting from this closest prior art document? It is not sufficient that the skilled person could arrive at the invention, but there must be some hint or some motivation. And if the skilled person would combine a further document to the closest prior art and then would render the invention obvious, then you get a rejection, else you get a grant under the further circumstances. So now in our specific context, when it comes to software patenting, there is the so-called convict decision. Because typically you don't have a completely technical invention, especially in the domain of software patenting. And what you typically have is a so-called mixed type invention. A mixed type invention is an invention which involves technical and non-technical aspects. And what the convict decision says is we just discard the non-technical features and merely take the technical features, and those technical features are considered when assessing inventiveness. So mixed type means we have technical and non-technical features, and only those distinguishing features which are technical are used when assessing inventiveness. On the right hand, you have the claim one of the convict decision of the application, which led to this decision. And you will find that we have indeed we could say software patent, more or less, or application. We have a method in a digital cellular phone system. And what we have here is technical features such as a SIM card, a subscriber identification module. And then on further, you see that we have splitting the charges between business and private calls. So this is I would call it a business feature. So we have the technical feature, more or less the SIM card, and we have, I would call it the business features, say the non-technical features, and when assessing inventiveness, only the technical features are considered. So the bottom line of this is that only technical distinguishing features are considered contributing to inventiveness. A technical solution for a technical problem will be granted. So this is very famous, and this is how the examiners examine the application, and they do a combination of the problem solution approach with the convict approach. And this allows us to clearly see what is happening further down the road. So the application domains when it comes to patenting software are very heterogeneous. We have fields that are rather hardware based. We have fields that are rather software based. For instance, if you have things like autonomous driving, you have always the hardware involved. If you are dealing with software development only, there might be aspects that are technical, but the software development as such is not excluded from patentability. Still, there is the common question for all these fields that are addressed on this slide: do you solve a technical problem with a technical means? So the mixed type inventions typically comprise hardware or technical aspects and software aspects, and the software aspects are technical or non-technical. So what we typically do is that we use the software parts of the invention and combine it with the hardware, and however address the hardware or something, bring about a technical effect using the hardware. But in general, the hardware is not always required. So we have issues where we deal with databases and the like, and they can have a technical effect, even if the hardware is not directly mentioned in the claim. So here is some aspects provided by EPO, European Patent Office, some guidelines. Well, you will find that these categories of features are not disjoint, they're not separate, but they overlap. And those are the features that establish technicality for a given invention. So we have to, first of all, or we have to have a further effect for a computer program, meaning that typically when you run on a software piece on a computer, of course you have some interactions, you have a technical effect, saying the hardware, the processors are used, the memories, the buffers are used, but this is a normal technical effect, not going beyond what the computer system is supposed to do. So what we need, one aspect we might need, one of these aspects is that we just provide a further technical effect going beyond what is the typical operation of the underlying computer system. The question, is a direct link to the physical reality required? This is heavily discussed in the case law, and the answer is not necessarily. So the enlarged board decided that there is no need to require a direct link with external physical reality in every case. So this might be the case or not, but no worries if you don't have this link to the physical reality. There are further issues which you can use for rendering the underlying invention technical. So is there a potential technical effect required? So the technical effect that would result from the intended use of the data could be considered implied by the claim. So you have to really look into the claim and what is really meant in the technical teaching, what is implied, how would the system behave if there is a technical advantage. The claim is rendered technical and is therefore open for a grant. Another question that arises is a virtual or calculated technical effect open to patentability. Well, this is an issue if you have a simulation or something and you don't have a feedback loop where your technical effect is put back into the machine, for instance, in the form of instruction commands or the like, then the computed or the virtual or calculated technical effect just provides data. So the calculated technical effect is just data. So you have to provide more typically. A tangible effect, meaning that really physical forces are involved or result. This is also not required, maybe required, but this is not a basic requirement. The implementation of a function on a computer is not against patentability. So there is not anything stating software being operated by a machine is patentable and computer software is not patentable. This is not the case. So there is no distinction between the software running on a computer system or on a client. This is or a machine. This is similar to the next category, methods performed by a computer. There is no distinction if you have a computer, a server, a client underlying, or some other technical machine. if the technical effect is achieved on that computer system, this is enough. So since a claim directed to a method of operating a computer involved a computer, it could not be excluded from patentability. So if you have a claim stating computer implemented method, there's no problem. So you have to still provide a further technical effect, but merely the fact that you run your invention or your resulting product or source code merely on a computer doesn't exclude it from patentability. So there's also no problem. And regarding computer implemented simulation methods, you might have a problem because this resulted from an application with pedestrian behavior simulation. How would they behave in specific situations? And the bottom line of this decision is that just a specific simulation of real world effects is typically not enough. There's still the so-called convict approach, which you have learned about in the previous slides. So it might be that a simulation is open to patentability, but still the convict approach, a technical solution to a technical problem, is applied. How could we now claim that we have established novelty, we have established inventiveness, and European Patent Office is quite clear on this issue. So you have methods and apparatus system arrangement claims, which you are all familiar with. We see this in different countries. What we rarely see is that you have a category like a computer program product or a medium storing a computer program product. But we are very clear in Europe that these categories are allowable, and typically when drafting applications, we claim these categories. So if you file a regional phase before European Patent Office, such categories might not be disclosed, but we can add them, for instance, in a direct filing. And even if we claim priority from earlier applications, we can still include those categories, but they will not get the application date of the priority application. But keep in mind, we have these categories and they're very helpful every now and then. Now, I want to present a very practical example of a patent, a software patent that was granted before European Patent Office. And you will learn that this is a very simple claim, a various obviously software patent claim. It reads a method of presenting data. So you see, this is completely software. Of course, we have some hardware issues involved, such as the data is stored in a data storage device 2, which in the figure is in the bottom. We have a data server 3, the user accessing said data server over a network. Easy, where in the process between accessing the server and presenting the data, at least one data path is used, of which control data associated with the selection of data is sent. And now comes the important part, set at least one data path is unidirectional. So you see, this is a pretty short, pretty broad claim, and it's more or less 100% software. There's only hardware involved that is typically involved, such as a data storage, which is common, of course, and data server. So this was granted before European Patent Office, and based on a German validation, was challenged by Microsoft before Federal Supreme Court in Germany, the highest court in Germany. And me personally, my law firm, together with some other colleagues, defended this claim successfully against Microsoft. So this is a completely valid claim in Germany based on a European software patent. And very exciting news that such a broad software patent claim is allowable and is still valid because nullity actions were dismissed before German High Court. So another trend of drafting patents is computer-assisted automated patent drafting. So we see this generative AI, Gen AI for short, issue in several domains such as automated patent search. And we also tried if we could use these approaches. We downloaded some libraries because if you would use it online, you might disclose the invention. But anyway, we used already published invention reports and tried to draft claims and the descriptions out of the invention reports. And the result was not promising. So the computer assisted or computer automated patent drafting lacks quality. So there was a lot of effort in correcting the claims, correcting the descriptions. So at this point, we find those approaches not very helpful. So further down the road, maybe 1 or 2 years, we might find something that is useful in our business. But as of now, we have to still wait for the large vendors and large companies to provide standards and especially quality standards for such approaches. So do we have to like program our own approaches? No, I guess there, and this is my personal opinion, there will be big companies, vendors, which will provide such solutions, and time will tell when we will find useful help for our daily business. Now that we know about substantive aspects, patent drafting, and so on, we go to procedural aspects such as filing strategies and post-grant strategies. Once we have our patent application ready to file, you should be all aware with the PCT approach and the roadmap. So what we, of course, can do is a direct filing before European Patent Office. Even we can claim priority within 12 months, for instance, from a US application. And the due date for filing the regional phase before European Patent Office is 31 months. So at this point, you have to really decide if you seek protection in Europe. So regarding the examination, there is specific differences in the offices, German Patent and Trademark Office, European Patent Office. And regarding hardware patents, applicants typically file before German Patent and Trademark Office and later use the regional phase before European Patent Office. Regarding software patents, I already introduced the could-would approach, the problem-solution approach, the convex approach, and so on. And I believe, and this is my personal opinion, that the roadmap of examination before European Patent Office is much more clear and foreseeable when it comes to patenting software. So I would only advise to file between European Patent Office. This is my very personal opinion, but I'm pretty sure. And then obtain, for instance, protection in Germany. And what you can also do is that you file a direct filing before European Patent Office. And based on the resulting PCT application, you can still obtain a second grant, which is shown on the right-hand side, before European Patent Office. So once the description and the claims allow for doing so, you can still get 2 grants based on a single draft, namely the direct filing and the resulting regional phase before European Patent Office. So this is not merely an aspect of the geographic issues, but rather about the examination proceedings. So what we have in Europe is what is quite new is the UPC, the unitary patent court and the unitary effect of a grant in Europe. So you can apply before 17 member states of the EU with a single request and obtain protection in these countries once you have a grant. Or you may be all aware with the current or the long-standing validation procedure where you pick individual countries and validate your grant in these specific countries. You can still combine those approaches, as not all EU countries are part of the unitary patent approach. So, for instance, Spain is not member of the unitary patent procedure, and therefore you can, for instance, apply patent protection with unitary effect in the 17 member states as of now and still pick Spain as an additional country. And also, not all 39 member states of the European Patent Convention are EU states. So there's even more. You can, for instance, if you have a European grant, apply in Switzerland or Turkey for patent protection based on a European grant. So now that we know about procedural aspects, what are the financial aspects, what are the costs, what is efficient portfolio management? Regarding your portfolio management, you know how to use your patents. Maybe your client or you as an IP department of a company want to use the patent protection for their own products, or you can also sell the patent or perform licensing activities. What you can do, for instance, is if you sell the patents in case the business field is given up, and this is very easy. You only have to provide a contract indicating the proprietor, the old one and the new one, and then you can transfer a patent quite easily. So if you seek to sell or buy patents, there's also platforms on the internet such as Patentable, where you just simply can buy and sell applications or even granted patents. You can browse through the offers and pick one and negotiate with the proprietor or with the applicant, and then do portfolio management and buy new assets or get rid of old assets which are no longer required. So the costs for filing patents in Europe are as indicated on this slide. What is very new, we have something like a small entity status, which some other countries had already long ago. You see, what you can do is you can do a EP phase entry based on a PCT application or a direct filing. What you see from the numbers, these are just numbers. Don't understand them as some kind of offer or something, but those might be the costs you have to face. And as you can see, entering the regional phase before European Patent Office is a little bit more expensive, merely because direct filings are newer applications and most of the fees are not yet due at the moment of filing. So you can pay them or you can pay them afterwards, but still you have to pay them. So the costs are more or less identical to those on the left-hand side. So if your client is small entity, it is less than 2 million turnover, and then you get and further requirements, which you see in the bottom, and then you get a 30% discount on filing, search, examination, designation grant, and renewal fees. So this might also be of interest. So this is it from my side. Now we will perform a questions and answer section where you get all your answers regarding software patents. We'll have an open discussion round, which is not recorded due to privacy concerns. Some words about me and my law firm. Well, I hold a diploma and PhD in computer science, so this might be of importance when considering the specific aspects of the software. So we would strongly advise only to choose really experienced and educated attorneys in this field. And we assist you in all matters of patenting software and hardware, especially in Europe, for instance, by filing direct filings or entering EP national phases. And what is also very important, if you want to connect, do so. We are on Inter. We still have time for appointments, or you might considering contacting us on Xing, LinkedIn, or we can meet up at International Trademark Association Inter this year, and we hope to see you soon. Thank you all for your attention and have a great day. See you.